Well, they train us that in order to keep somebody's attention, it's good to change the environment. So you get a new background for this section. I hope you're enjoying the training so far. We just got done talking about autonomy and respecting people's autonomy and all the different types of considerations that go into that ethically. Now we want to shift to something called red flag laws. And I put that in air quotes, red flag laws, because that's actually a nickname for something called extreme risk protection orders. So what is a protection order in the first place? Well, you may have heard the term, restraining order, temporary restraining order. That's something that comes through pop culture and media and TV shows and movies and so forth, particularly dealing with law enforcement and the courts. And what they are really is a protection order, and it protects a person who files against another person because they believe they're in harm's way, or maybe we put a protection order against a person who's violated another person. You can't go within 500 feet of them, or you can't visit them at work or something. And then there's usually a duration of time affixed to that, 90 days or a year or something like that. So extreme risk protection orders then speak to firearm specific instances where an individual needs to be separated from his or her firearms, and this is done through compulsion through court of law. We'll go through some of the language here in a minute, but essentially what this means is that a person could file an application with a court to have a judge review some evidence that they present. And then this judge reviews the evidence and says, yay or nay, we should or should not take this person's firearms because they pose a risk to self or others. Okay, so let's go to the first slide here, and I'll walk through some of the language. I'm going to stick with Nevada because I know Nevada the best, but I have studied a number of other states' laws, and you can just take my word for it that they more or less mirror each other in their spirit and intent. Some of the language may change, and I'll touch on that in a little bit, but essentially the crux of it is the same, which is what I just explained. So let's look at Nevada. So NRS stands for Nevada Revised Statutes, and the revised statutes in Nevada are our state laws. There are also a set of regulatory codes behind those laws that augment, clarify, and expand them in some cases, but the state laws are NRS, Nevada Revised Statutes. So you'll see the chapter there, 33.500. Through 33.670. So this is how you file a verified application, and you'll see some language there for ex parte or extended order. Ex parte is Latin. It simply means one party has to be present to execute this thing. Extended is extended. It goes beyond the initial order. So who can do it? Number one and number two. Just bounce back and forth there. You'll see a law enforcement officer who has probable cause, or number two, a family or household member who reasonably believes. And then the language after that mirrors in both of those. So what it essentially says is a law enforcement officer has probable cause to believe a person is at risk of injury to self or others by possessing firearms, can file this verified application. And then a family or household member who reasonably believes. And why did I highlight those? Well, I'm glad you asked that. So what I'm illustrating here is something called a burden of proof ladder. It's something that's used in law enforcement and actually in financial investments, and it's used all over the place. But for our purposes here, we're using it for application to get this extreme risk protection order. So the burden of proof ladder starts low with reasonable suspicion, or you might reasonably believe something. That's you got some stuff together. You can put it on paper. It's a little bit beyond smells funny or looks funny, and you can actually articulate why you reasonably believe this. And the so-called litmus test is against whatever another reasonable person would also ascertain from this information. Above that, we have probable cause. You probably heard this in the same TVs and movies and whatnot, or TV shows and movies and whatnot, that the law enforcement officer had probable cause to enter the home. What that is a next step up on the ladder of proof to basically say, I have more information than not that would indicate that I should have acted. So the burden of proof in this case compels somebody to act with the articulated rationale behind it. Now, I say this in clinical settings too. I teach my students and my interns that you should act in such a way that if examined by some parent or a disinterested third party, or God forbid we end up in court where the CNN cameras are rolling and they ask, why did you do what you did? What is your intentionality behind it? And we should reasonably be able to explain to any other reasonable person that we assigned the journal article, or we assigned a journal to write in, or we assigned some sort of homework to take home, watching emotional functioning videos, for example, and say, the reason I assigned this is because it aligns with their treatment plan and my outcome is supposed to be greater emotional awareness, or I wanted them to reflect on their thoughts, or whatever it may be. So the same type of instruction should occur with the same type of intentionality in clinical settings as well as in law. So here's what we need. We need a family member to have reasonable belief and a law enforcement officer to have probable cause before they file the application with the court. Now, if we look at the next slide here, we see that the judge can issue this order based on something called the preponderance of evidence from the facts shown. So here you say, how do we issue this ex parte order? And you see the court shall issue, it doesn't say may, it says shall issue an ex parte order if the court finds by a preponderance of evidence from the facts shown, and then A, B, and C. So I'll get into those in a minute, but I want to hover here on the preponderance of evidence, because preponderance of evidence is yet another step on the ladder above probable cause. What you're essentially saying is the likelihood of these things to be true greater outweighs the likelihood that they're not true. So it's just a little bit above probable cause, and it's 2 steps above reasonable suspicion. But the interesting thing is that they're determining their probable cause, or they're determining their preponderance of evidence based on what's in the application. So you've got a reasonably suspicious family member, and then the judge is supposed to take that information and determine a preponderance of evidence from what's listed on there. So that already gets into some gray area about whether or not the person filing the application is telling the truth, and whether or not the judge believes them. So that could cause some friction. But let's go into what's supposed to be on the application. A, the person poses an imminent risk of causing personal injury to self or another person by possessing or having in his or her custody or control, or by purchasing or otherwise acquiring any firearm. The any firearm is significant because it encompasses all firearms as defined by law. And I'm not going to go over that. You guys can imagine what those might be, but they are defined in statute. So that's plank number 1. You see the semicolon there, it creates a list. We go to B, the person engaged in high-risk behavior, semicolon, and you have to have C also. Less restrictive options have been exhausted or are not effective. So when you see a list like this in law, don't be confused by the legalese. It means that all 3 must be met. If it said or after B instead of and, then it would mean that only one of those would have to be met in order for this order to be issued. So what we have here is what looks like a pretty high bar to meet or to clear in order to issue this order. But here's the problem. We've got some language in here that is not necessarily concrete. So what is imminent? Well, imminent, I think any reasonable person would conclude, is like right now, like right now, immediately. So imminent risk. That's probably not, well, I'm thinking about maybe in a week or so, or maybe 30 days from now. It's like right now. And then the person engaged in high-risk behavior. Again, very subjective. What I think is high risk may not be the same as what you think is high risk. You may enjoy jumping out of airplanes with a parachute strapped to your back. I may think that that's too risky for my taste. I don't know if that's high risk. But if I'm the one filing the application and I have a very disparate idea or very divergent idea of what high risk is, then I might be accusing you of engaging in this behavior that you think is perfectly normal. Drinking, for example. I may be a teetotaler who doesn't like drinking alcohol. You may have 2 drinks a night, and I think that's risky, right? Okay, let's go on to C. Less restrictive options have been exhausted or are not effective. Again, very subjective. If you've been in counseling for 6 weeks and I've seen you an hour at a time for those 6 weeks and you're still vaguely suicidal, you're maybe a 5 on a scale of 1 to 10, then I don't know that I have not been effective. For all I know, I have been effective because it hasn't increased from a 5. Maybe I have not been effective because you haven't gone down to a 2. So if a family member or a law enforcement officer is seeing all this information and they say, well, you drink every night, you're still stuck at a 5 on the scale of 1 to 10. I've checked off B and C. Now, how imminent is that risk? If you've been in counseling for 6 weeks, I don't know that it's that imminent. But again, highly subjective. If somebody's very scared and they're operating out of a fear impulse instead of logic, they have enough to put this application together to go to the court and say, you know what, I don't care what the professional says. I think they're imminently at risk because they're always talking about suicide. They engage in high-risk behavior by drinking every night, and they're talking about going parachuting this weekend, and counseling isn't working. Take their guns. A judge may look at that and say, yeah, preponderance of evidence is such that this is quite likely. So then the court, down in number 2, may require the person who filed the verified application or the adverse party, meaning the one who's being accused, or both, to appear before the court before determining whether to issue the ex parte order. But, number 3, an ex parte order may be issued with or without notice to the adverse party. And that's a little screwy in my estimation, because the person could get surprised by this. And if you're talking about somebody who's that imminent of a risk, engaging in high-risk behavior, less restrictive options have been exhausted or not effective, do you really want them surprised? On the other hand, time is of the essence, right? So, what's a judge to do? And really, like, as we get into this more, we're going to have to examine what I mentioned earlier in the steps to intervention that should not include this particular path, because by its own nature, going before a court, especially if the court's closed or whatever, the most quickly something like this could get turned around is maybe hours. And I don't know that hours necessarily is useful in a quote-unquote imminent risk situation. So I just think this is probably a bad idea on its face, but it makes people feel good. It's like, we got this law and it should be used, and that's great, and we'll just separate the person from their guns, and we'll use government to do it, and we'll have the deputies knock at their door, and they'll take these weapons, and the person will be safe, right? Okay, except that doesn't necessarily mean imminent is being met. All right, let's go on a little bit here. So I mentioned burden of proof earlier. Let's look at how these get expired or dissolve, and of course renewed. So number 1 here, an ex parte order expires within a time that is set by the judge that's not to exceed a week. It says 7 days in there, but you see the as the court fixes language. That means that the judge can say, all right, we're separating this person from their guns for 3 days. All right, well, it's not 7, but they could go up to 7. For our purposes, let's just pretend it's a week, because it'll remain consistent as I continue talking. If the verified application for an extended order is filed within that period, okay, within that week or that 3 days, or at the same time, you can file them simultaneously, then the ex parte order remains in effect until a hearing on the extended order is held. So this is how it plays out. File the ex parte order, or the application for the ex parte order. It gets issued. Now, a hearing may not happen for weeks or months. In the meantime, that person does not have access to their firearms, because in order to extend the order, you have to have a hearing. No more ex parte. You can't just surprise the person, right? So now they have to have a hearing. And then it says the extended order expires within such time not to exceed a year as the court fixes. Same language as above. So basically the court, the judge, can say, all right, I'm assigning 3 months to this. Well, if you've already spent 2 months waiting for your hearing, now we're talking 5 months, plus maybe that week that you waited. So that's already a problem. It takes a long time, especially if you're, by now, 2 months have passed. I don't even know if the information is still valid at that point, right? And then number 3, how do we get rid of this, right? The family or household member or the law enforcement officer who filed the initial application may request in writing to appear and move for the dissolution. Now, it also says the adverse party. So if I'm the one who's struggling and somebody red flags me, I can go, whoa. This is total nonsense. I want this dissolved. Okay, but here's the kicker. Upon finding by clear and convincing evidence, we've gone one more rung on the burden of proof ladder, above reasonable suspicion, above probable cause, above preponderance of evidence, and now we're at clear and convincing evidence. So all it took to restrict my rights, to take my property away, even temporarily, was reasonable suspicion on an application that the judge then thought was, had enough evidence to sustain it. But now I have to go provide clear and convincing evidence, which is even higher still, that this thing is not actually the way it is. Above that would be beyond a reasonable doubt, or beyond any doubt, or beyond a shadow of a doubt. You've heard different language about that. That's the top of the burden of proof ladder. But for right now, what we have is a very low bar to rights restriction and a very high bar to rights restoration. This is a problem because this requires resources. And if you take the example of, say, somebody who's been a victim of domestic violence. They're recovering. They've survived. They've moved on. They've separated, but they chose to buy a firearm to defend themselves from this person who is, violent and abusive. Let's say that victim of the domestic violence is still struggling because it takes a long time sometimes to overcome post-traumatic stress effects and so forth. Let's say that they're saying, man, I don't know if I can go on, these nightmares, I keep having flashbacks, I'm hypervigilant, I'm constantly looking around every time I go to the grocery store, I just don't feel safe even though I have a concealed carry permit, I'm doing fine. The person that hears that may be one of those family or household members who says, I don't think you're safe, files the application. And now what you've done is you've taken the very mechanism away from the person who bought it to defend themselves and essentially left them open to victimization again. They don't have anything to defend if you took away the one tool that they thought was the most powerful to provide that defense against that, maladjusted party who is perpetrating the domestic abuse and the violence. So we want to be mindful that when we're looking at these laws, we're not creating unintended consequences down the road. I want to switch topics here for a second to something else, because we're talking about stepping on people's autonomy. Maybe we're doing it out of a sense of justice. Maybe we're doing it out of a sense of beneficence. Maybe we just don't want them to harm themselves. That would be non-maleficence, right? So these things are all wrapped into ethical codes, and we can have a robust ethical dialogue about it. But I'm not sure those things happened in laws such as this. Let's take a look at some data that were mined and pulled together by Sandy Richardson, who was a guest on our Walk the Talk America Guns and Mental Health podcast. She was on twice, and she's a victim of the New York SAFE Act, which took her ability to possess and own firearms away from her, but it was done through a false report. So she's fighting this battle, and you can hear all about her story on our podcast, particularly the most recent one. But what she pulled are some numbers from New York State. And you'll see these on your screen. New York State population 18 years and up, 16 million people, right? 16 million and change. There's an estimate of 20% of those citizens who are 18 and over owning guns. We know this is a low estimate because nationally, I've said this before in the presentation, it's more like half who either own a gun or live with one. And the conservative estimates on gun ownership alone are about 30 to 33%. So let's just pretend it's 20%. That still constitutes 3.2 million gun owners just in New York State. Now, there's a research paper that we also reference in here, and it comes from an article in Psychiatric Quarterly in 2021, based on a publication that came out August of 2020, that shows that a study was done in New York at two different counseling agencies, two different facilities. 228 patients were polled who responded to their questionnaires, and what it resulted in was we discovered about 18% were concerned about being reported to the county government, which I'll go over in a minute. 9% would be less likely to seek mental health treatment, and about 23% would be less willing to report mental health symptoms and behaviors. So this is interesting because we already have an incidence of sampling bias here, and sampling bias occurs when the people you draw for your survey or your study are already predisposed to believing one thing or another, or they're demographically skewed to one demographic or another. The sampling bias here that's inherent is that these people were already in care, meaning they're already gun owners who wanted to, or not gun owners, who sought out mental health care, right? So this is really important. It means that the New York SAFE Act is not a burden already to entering care. They're not already spooked by it, but yet 9% of them would still be less likely to seek mental health treatment, which is significant because if we go back to our numbers, let's say our 3.2 million gun owners, that means that 9% of those, 288,000, would be less likely to seek care. That's a big problem. You're talking more than 250,000 people who are turned away from seeking care because they don't want their rights taken. And I don't know that the New York SAFE Act is helping to stop, violence and, gun crime and suicides by gun, if what they're doing is pushing people out of the very help they need that would solve the problem. Let's look at the New York SAFE Act here, and we'll put this up on your screen also. So this is section 9.46. This is called reports of substantial risk or threat of harm by mental health professionals. So just take out that middle part there. Reports by mental health professionals is how it reads. For purposes of this section, the term mental health professional includes the following people, of which I would be one: a marriage and family therapist in New York, a mental health counselor. Skipping down to B, you go about 1, 2, 3, 4, 5 lines down. It says he or she shall be required to report as soon as practicable to the director of community service, director's designee, et cetera, et cetera. And then skip a couple more lines. It says that those people will determine whether a license issued, and this is a gun license, a license issued pursuant to Section 400 of the Penal Law, that's their gun license law, whether that license should be suspended or revoked, and subsequently, down at the bottom, you're no longer permitted under state or federal law to possess it, all because a mental health professional reported that you were struggling with mental illness that gave rise to the idea that maybe you were at risk of harm to self or others. Interesting still is subsection D says the decision to disclose or not disclose when made reasonably and in good faith shall not be the basis for any civil or criminal liability, meaning I could make this call that restricts your rights, that steps on your autonomy, that revokes your ability to, own or possess firearms, and there's no penalty for me if I do it incorrectly. And that was the case in Sandy's situation, where we suspect probably there was some activism maybe taken that was not in good faith, but you can't prove that. All you do is you go back to the person and you say, hey, why'd you do this? And they say, well, I thought. Reasonable suspicion, right? But meanwhile, the adverse party, Sandy in this case, had to prove clear and convincingly that she was fine. And again, I really encourage you to hear her story, because it's quite harrowing, and it does keep people out of care. I think that's a big problem when we when we're talking about taking people's property away from it. So let's move on here. You go, well, aren't there other ways we can deal with this? Can't we just voluntarily give up our guns? Isn't that what your organization is all about? Yeah, actually, absolutely. It absolutely is. But when we get into transfer laws, that's a bigger issue, because there are prohibitions in transferring the firearms that don't allow us to do the right thing in good faith, because we could become criminals ourselves. Let's go back and take a look at Nevada Revised Statutes, different chapter. This is 202.2544. So this took effect the same year from the same legislative session in 2019, took effect in 2020, as when the red flag law was passed. So take a look here. So some of the super judgmental language that I really take umbrage with is actually embedded into our laws. Usually you don't have whereas clauses put into actual law. Usually the whereas clauses, which are the little clauses that explain why a law is important, are left out. And that's just left on record. If you wanted to go back and examine why the committee did what it did, or why the testimonies were the way that they were, it's because it'll say, whereas such and such, whereas such and such, whereas such and such, therefore we want this. Well, Nevada wrote its whereas clauses into law, and you can see here, to promote the public safety, federal law currently prohibits felons, domestic abusers, and then I highlighted there, the severely mentally ill and other dangerous people. Well, if we're trying to destigmatize mental health and mental health care and mental illness, we can't be lumping in mentally ill with other dangerous people or dangerous people at all, because we know by statistical analysis that mentally ill people are way more likely to become victims of crime than to perpetrate the crime. So let's look at the next slide here. We go from section 1 to section 2, where it says criminals and other dangerous people. So now we've got a linkage of the mentally ill, dangerous people, and criminals. So it's like it's against the law to be sick. They can avoid background checks by buying guns from unlicensed firearm sellers. Well, that's true, but you're limited to how many you can sell, except not anymore. So this law was passed somewhat in bad faith, because there was no background check loophole for gun shows. Gun shows were always attended by firearms dealers who have licenses from the federal government. So the likelihood of this happening is very, very, very low to begin with. And let's face it, criminals don't follow the law anyway. So we've got criminals and other dangerous people lumped in with the mentally ill, and then we skip a couple sections to number 6, which has more, linkage to the judgmental language. It says, we have the right to bear arms, comma, but with rights come responsibilities, which we agree with. You have to be responsible with your rights, including the responsibility to keep guns out of the hands of convicted felons and domestic abusers. So now we've got the mentally ill, criminals, dangerous people, convicted felons, and domestic abusers all lumped together under this transfer law, which then goes on to say exceptions to, which says you can transfer a firearm without a background check in the yellow font here. Okay, what are the requirements here? You can transfer it to a person who's not prohibited. So me to you, for example, we're not prohibited. We're not on any lists. We didn't domestically abuse anybody. We aren't convicted felons. So we're not prohibited. If it's A, necessary to prevent imminent death or great bodily harm. There's that imminent language again, and great bodily harm, which we would presume is, inherent in firearms use. Semicolon, and. So you have to meet both these criteria. Lasts only as long as immediately necessary to prevent such imminent death or great bodily harm. The problem is we don't know what constitutes temporary, and we don't know what constitutes immediately. So you can temporarily transfer as long as it's immediately necessary. And Oregon's law actually, because we did a presentation up in Oregon that suggests that for the purpose of preventing imminent death, same language, or serious physical injury, they don't say great bodily harm, they say serious physical injury, and the provision lasts only as long as necessary to prevent the death or serious physical injury. So we still are left with this problem of subjective language. And what is temporary? Is temporary 12 minutes? Is it 3 days? Is it 30 days? Is it 3 months? We don't know. So you can say, well, that's fine. Act in the moment. Do the right thing, right? If my neighbor is struggling, we're not related by family, we're not domestically dwelling in the same home, I'm not a law enforcement officer, I'm just trying to do the right thing because he's expressing suicidal ideation, and I say, hey, you know what's a good idea? Why don't you give all your guns to me, and I'll hold on to them. The problem is, if I, let's say, have my home broken into 3 days later, and there's all these guns that don't belong to me, and the cops are called, and they're like, hey, do you own all these? And I'm honest, and, I admit, I said, no, actually, I'm possessing them for my neighbor who's struggling. He's looking to find an appointment. We live in Nevada, where it's impossible to find appointments immediately. It takes weeks or months sometimes to get into care. It doesn't level up to maybe necessarily needing a hospital admission, but I'm trying to do the right thing to keep him safe because the firearm was the tool that he had ideated using. The police now have a problem because it's up to them to discern whether or not immediate is in effect 3 days later or 3 weeks later or however long it is. And back to the screen here, you'll see that the penalties in Nevada for violating this background check, for the first offense, we have something called a gross misdemeanor. It's something between a misdemeanor and a felony. And then for the second offense, you're guilty of a Category C felony. Now, I know I raised in a family full of cops. I've taught the police academy here for a number of years. Again, the determination of what the infraction is can vary from officer to officer, from sergeant to sergeant, lieutenant to lieutenant, and they may actually look and see my 15 guns that I took from my neighbor for the to get through the crisis and go, one gun is a gross misdemeanor, and every subsequent one that I possess falls into that Category C felony. Now, a reasonable person probably would say the act alone is one. So maybe I'm willing to take the gross misdemeanor because I kept my neighbor alive. I don't know how many people are willing to do that, especially when these laws are on the books. They're unclear. They're highly subjective. And I don't want to become a gross misdemeanor. I don't want to become a Category C felon, especially these days when the felony sticks with you forever, and which is another discussion about prison reform and how we really need to quote unquote ban the box, which is the box that you check that acknowledges that you've been convicted of something. Because I may have been doing the right thing, but now I'm wrapped in a legal battle that's very expensive. I may go to jail. On top of that, I may have all my guns taken from me. The whole thing is just a big mess, and it's pretty clear that law enforcement was not consulted when these laws were written. mental health was not consulted when these laws were written, and all they're doing is obstructing care access in a time of need in a state, by the way, in Nevada, that's dead last in behavioral health care and provision and has been for many, many years, all because, I don't know, the laws were written in haste or in ignorance or I don't know what, but we're pushing people away. Now, how do we know this? Well, we know it from the research paper that Sandy Richardson shared with us. We know it anecdotally through our social media accounts at Walk the Talk America, through emails that we get, through emails that I get, text messages that I get on a regular, constant basis, multiple times a week, asking me about this, asking where people can go to make sure that they're not going to be landing in a clinical office with a judgmental or activist clinician who maybe is anti-gun and just wants to restrict rights, or maybe is acting out of fear and ignorance, saying, well, I don't know that you're safe with your guns, but I'm not going to take your word for it. I have this law at my disposal and I'm going to use it. There was a push in 2019 for federally to create a nationwide red flag law. And now the more that we encroach onto this territory, the more people we're going to see added to these types of laws. The New York SAFE Act that, I'm holding right here in my hand, Section 9.46, a year or two ago, did not list counselors. It did not list marriage and family therapists. It listed physicians, psychologists, nurses. Now they've got psychiatrists, mental health people who are compelled to make this report. So, 3 years ago, I wrote an article for Walk the Talk America that said counselors cannot take your guns. Now that's increasingly untrue, and that compels us to give more urgency to creating our 50-state directory of firearms-friendly practitioners who aren't just going to pull the red flag lever simply because they have a gun owner from military history, law enforcement, current or former occupation, domestic abuse survivors, who's sitting in front of us ideating anxiety or depression or PTSD, and they happen to own guns and recreate with them or use them for defensive purposes simply because I'm acting out of a position of fear and ignorance. So we need to be aware of these things. Walk the Talk America doesn't take policy positions. What we try to do is educate. And we're hopeful that in educating you through this tutorial that you'll become more savvy as to how these laws work, how they apply in your own state, and whether or not you, as a practitioner with a license granted by the state, are legally compelled to breach confidence, step on somebody's autonomy, and revoke their civil right to own a firearm as they see fit, as granted, or granted by God and protected by the Constitution. We also have other ethical implications that suggest, things like higher level of care and whether or not we breach confidentiality or act to protect. So, at some point, if Nevada, for example, the legislature decides to add professional license holders to this list of people, it's no longer just law enforcement or family household members, it's going to have to reconcile some other things that have to do with confidentiality protections, and they're probably going to have to reconcile it with HIPAA. HIPAA is federal, and we're not allowed to breach confidentiality, when disseminating information electronically or otherwise. They're also going to have to come up against 42 CFR, which is the Code of Federal Regulations section that deals with drug and alcohol centers, because if you breach confidentiality simply by admitting somebody's in care at that agency, you're inherently saying why they're at that agency, which is a confidentiality breach. So this is a big bag of problems that our legislators really need to become aware of, and we as clinicians need to be very, very judicious in how we execute our interventions and not reach just simply out of fear for the legal intervention lever, instead opting for higher levels of care or wrapping the family members in. I don't want to be training people on how to red flag their family members. I'd rather train people on how to support their family members so that rights remain intact and we don't end up involuntarily pushing away people from care. So with that, I'm glad you're listening, and I hope you take this around and share it with people.